ruling that has been delivered by this Honorable Court. While we largely disagree with it and we have a right of appeal, Your Lordship, it is imperative for us to know or to assess how that office of the Deputy President will be filled. This court has affirmed its commitment to observe the rule of law and protect the Constitution as decreed under Article 3 of the Constitution. It follows, therefore, Your Lordship, my ladies, that the filling of that vacancy must flow or must follow the Constitution. And as such, Your Lordship, and as much as I have not heard the court address that very pertinent issue, it is my submission, Your Lordship, that I rise under Rule 23. Beg your pardon. Rule 23 and Rule 24 of the Mutunga Rules. And I make an application, Your Lordship, that pending the determination of this application, done under Rule 24, that this Honorable Court does issue conservatory orders suspending the swearing in of Professor Kindiki on the following grounds. Your Lordship, Article 10 of this Constitution, of the Constitution, bids this Honorable Court to observe the rule of law. It further calls upon this Honorable Court to commit itself to ensure that there is good governance, there is accountability and transparency in the manner in which matters are done or functions are executed.
My Lord, with your kind permission,
it's an application.
Mr. Jiro has referred to an application for which he's seeking some orders pending, but we haven't seen any application in that regard.
Yes, Your Lordship, if Mr. Kamotho was keen to read the rules, the Mutunga Rules allows me to move you informally. And subsequent to me making an application informally, the court is called upon to reduce the same into a formal application. And that, Your Lordship, I want to draw his attention to Rule 24, Sub-Rule 1. An application under Rule 23 may be made by way of notice of motion or by an informal document. Your Lordship, permit me to proceed with the grounds of my application. It is clear, Your Lordship, that the court...
My Lord, if I may, I respect my learned friends. My Lord, I respect... Yes, I respect Mr. Njiru. He's referring to an application that is non-existent. Either is referring to E554, Mr. Kamina, sit down. E554 of 2024, which is before the Court of Appeal, if you are referring to that application. But my Lord, if my learned friend is referring to the exercise of this court of epistolary jurisdiction, then he should say so. But he cannot refer to the exercise of that jurisdiction, my Lord, when this court is functus officio. You have rendered yourself on the question of the application. And therefore, they cannot urge an application unless they say, my Lord, number one, is either served on us, or two, my Lord, because there's already an application for stay under Section 5(2)(b) of the Appellate Jurisdictions Act before the Court of Appeal that is live and that has a date. This court would not have jurisdiction to entertain any other application for stay. They tried making an application before the Court of Appeal this morning using the same issues, my Lord, and the Court of Appeal rejected the application. They were told to serve everyone else. So, my lord, for my learned friend to come here and to seek to apply for stay again, having a second bite at the cherry, is dishonest, my lord. It's dishonest. They are before the Court of Appeal.
So, may I suggest, Professor Gender, that that could be your response to the application which will be made by Ndegwa?
Yes, if there's an application, yes.
Thank you, Your Lordship. Your Lordship, permit me to move on with my application, and I urge Professor Ogenda to have a look at the rules that I have just referred to. That, Your Lordship, you be kind enough to interrogate the circumstances under which that office shall be filled. Your Lordship, it is on record, and I invite the court to take judicial notice, that there is a clear non-existence of a crucial state organ that is supposed to oversee the processes of filling of that office in the name of the Independent Electoral and Boundary Commission. Your Lordship, the Independent and Boundary Commission is created under Article 88 of the Constitution, and the functions are created therein. One of the functions, my lady, is to maintain a voters register, is to register voters. Under Article 99, Your Lordship, of the Constitution, as read together with Article 137, creates the qualifications upon which the president or the deputy president must attain if one is to hold office. My ladies, my lord, it is clear that the functions created under Article 99 of the Constitution can only be executed and or implemented by the Independent Electoral and Boundary Commission. It goes without saying, my ladies, my lords, that a deputy president designate or nominated must attain those qualifications. That is to mean, my ladies, my lord, that there must be an organ that will give a clean bill of health to say or to suggest that Professor Kindiki attains these qualifications. My lords, my ladies, I refer to the memorandum that was sent to the Speaker of the National Assembly by the President of the Republic of Kenya, dated the 18th of October 2024. In that memorandum, Your Lordship, the President drew the attention of the Speaker to the clearance of the designated candidate by the IBC. And this is what the President had to say. Your Lordship, the President indicated that he has had confirmation that Professor Kindiki meets and attains the qualifications created under Article 99 as read together with Article 113 of the Constitution. My ladies, my lords, when the President of the Republic referred to the IBC, and I call upon the court to take judicial notice of that document, it was a presumption that that confirmation was done by the Electoral and Boundary Commission as created by the Constitution. My ladies, my lords, it is my humble appeal that this honorable court does fight in my favor to issue the conservatory order on the basis that there is no clearance that has been issued by the IBC.
My lord,
we all know, my ladies, my lords.
My lord, may I kindly seek your guidance? When Mr. Giro started off, we thought it would be a simple and a straightforward application. But now, seeing the trajectory it has taken, he has raised an avalanche of issues for which we would require them reduced in a particular format so that we can seek instructions from our clients. So we'll be seeking that we get a formal thing that will enable us to seek instructions from our clients. Dr. Kamodo for the 10th respondent.
Your Lordship, I am making an application on the basis of the law. Your Lordship, if it is not crucial for us to have an IBC to confirm whether Professor Kithure Kindiki is a registered voter, that would mean, Your Lordship, that a person can go to Mathare Hospital and designate a person to become a deputy president. The qualifications created by the Constitution have a mechanism of being established, Your Lordships. And the process of establishing those qualifications, Your Lordship, is set down and out in law. Your Lordship.
Mr. Njiru, my understanding,
yes, Your Lordship.
When we first asked for this conservatory order,
yes, Your Lordship.
under Madu paper,
yes, Lord.
That
is his application.
Yeah.
I have on a different application. I moved under Article 23.
Because my understanding is that if you want the court to give conservatory orders immediately after rendering a ruling or a judgment, that application can be verbal, but also very short, because the court is already aware, has already expressed itself.
That's correct.
So that kind of application cannot be the beginning of another big
Your Lordship, I am well guided.
So I think for the purposes of the discretion of the
yes,
bench,
Lordship.
For the purposes of the discretion of the bench,
yes,
I think Mr. Ochieng's application is what we should be considered. Your application evidently requires to be formal.
Your Lordship, I am well guided by the court, but the court also needs to perhaps appreciate the import of Rule 24. That due to the vulnerability of the rights and the vulnerability of the infringement and the violation of the Constitution, I can appear before you.
Rights cannot be vulnerable. Individuals are.
May I have
not
my
rights.
time and then you have your response, Professor? Your Lordship, this application is premised again on Article 3. The call upon every person to protect the Constitution. And as I pen off, it is all clear to us that nobody can deny, not this court, not myself, nobody can bury his head under the sun, that there is no IBC. If Kithure Kindiki is to be sworn in tomorrow, what will be the import of swearing in a person who has not been verified and approved by the organ that is supposed to do so? Finally, Your Lordship, can this court fold its hands and watch and midwife and babysit a violation of the Constitution? What is the role of the court when it comes to the issue of Article 3 of the Constitution and the question of the sovereignty of the people? Your Lordship, I beg that you hear us. I beg that you grant the conservatory order staying the swearing in of Professor Kithure Kindiki on the basis that he has not qualified to hold that office. Secondly, on the basis that his purported qualification has not been verified by the body that is mandated to do so. In the absence of that, Your Lordship, you will be inviting us to say that even an insane person can become deputy president, a bankrupt person can become deputy president.
Objection.
I rest my case.
My Lord, let me respond to...
So that
can I respond?
Professor Ogenda and,
yes, my Lord.
And every other counsel who is seated, please sit down. We have two applications, and this is not going to be a start of another court process. It's not going to be a start of another court process. The applications which have been made are discretional. So I'll only allow one response, and then we'll render a ruling. Only one response.
Yeah, my Lord, if I may respond, my Lord.
My Lord, kindly, with your permission. With your permission.
My Lord, you've made a ruling.
Okay. Okay, let me hear two people from this side.
Okay. Then two from... You're one person.
Dr. Kaminwa, please say what you want to say and be mindful of time, please.
Yeah, I won't take my time. Justice Eric Ogola, Justice Anthony Murima, and Lady Justice Frida Mugambi. I've listened to what you have said very carefully. And from my point of view, one who is interested in developing the students of the country, you have done so. You have developed the students of the country. But there is one thing I would like to point out to you very respectfully, that we are operating in very dangerous waters with strong currents. And this is an area where we have to call for wisdom. We have to call for deeper understanding of human nature and for deeper understanding of the society in which we live, Kenya. And what I'm saying to you is reflected in my broad reading of the authorities in cases in the United States of America. Your Honor, if I may say so with respect, perhaps more than anybody else, when I was engaged to get involved in this case, I ordered for books from India straight, about 11 volumes on impeachments. And I've taken the trouble to read them day and night. And one thing that has emerged from all these authorities when I was reading them very carefully is that the courts in the United States have continued to think very carefully, how will this judgment be received by the people, by the consumers? How will it be received? Is it a judgment that will continue to promote stability in the country? Is it a judgment that will continue to promote the rule of law? Is it a judgment or ruling will continue to promote stability in the country? And it's here that I'm inviting you very respectfully that you consider the able remarks of my learned friend, Mr. Gachagua, that we should not, and my learned friend, Mr. Ochiel, we should not ignore what they are saying lightly at all. With a tremendous respect, we don't want to move out of this courtroom and then all of a sudden we are told that there are protests now in such and such an area. My Lord, I'm not trying to intimidate anybody at
Just
all.
order.
All that I'm saying to you, Your Lord.
Sorry, my lords. The utterances by the Honorable Dr. Hamino.
I'm not honorable.
I'm giving you the title.
No, what I'm saying, let me say what I want to say.
And unfortunately, they're insightful. They are trying to preempt matters that are not before this court. We do not know and we cannot speculate that anyone is going to be happy or unhappy about it. The sword of justice cuts both ways. There are those who are going to be happy, there are those who are going to be unhappy. That is how life is, but you cannot incite by saying from here, we will have protests, we will have what? We do not know of that. And unfortunately, my lords, I ask you to kindly restrain him from taking that route.
With your kind permission, Your Honor.
Please sit down. Please sit down. We want you to know that we have rendered ourselves in this matter. We have rendered ourselves in this matter, and we are not going to open this matter for a further court proceeding. There are two applications before the court, one by Dedlo Chieng and one by Ndegwa. After Dr. Kamuna has spoken, we'll allow two people to respond, and then we'll make a ruling.
My Lord, I was to also, you indicated that two people, and I was prepared kindly to make an application.
Continue, Dr. Kaminwa.
No, my lord, I'm actually it's on one sentence. When you read the books I have referred to the authorities in America, the judges have made a finding along these lines. Yes, this is the legal position. So and so is guilty. But we shall not go ahead to do that at all. We shall leave him to continue. So that's all I'm saying to you. You have come up with a very, if I may say so, a ruling full of jurisprudence, and particularly my Lord Justice Murima has come up with something that I had not thought of very much at all. But all that I'm saying to you, that you are liberty, you still have the discretion to say that, look, these are our findings, but still we are going ahead to give conservatory orders for so many days or so many weeks. So you still have that discretion for the sake of the country. Thank you.
My Lord, in brief response.
May I kindly, my name is Sam Nyaberi. I appear for the 9th petitioner in the 2nd cohort. My Lord, I stand to make an application for stay of the orders that have been issued this afternoon relating to the application that was before you, and having keenly listened and internalized the import of that ruling or order, my Lord, we wish to move the court, much as we have that opportunity by way of the orders that were given, that we were given a right to appeal, that pending the appeal, pending the lodging of the appeal, my Lord, my Lord and my Lady, you allow us that opportunity of stay so that we can ventilate our issues before the appellate court. My Lord, what informs this application is that there is an apparent risk by the fill-up of the position of the Deputy President, and in our petition, we had named the Professor Kindiki as a party in the petition that we had filed for the 9th petitioners. So that, my Lord, having analyzed and internalized that, we feel that the petition, in the fullness of time, when the court is going to process it, we will be dealing with an issue that perhaps will compromise the rights of the 9th petitioner who has moved the court. And, my Lord, the other issue is that there is a period within which the respondents, if they have to move, they have to fill up that position of the Deputy President. So that, my Lord, there is no any prejudice that will be occasioned to the second respondent if the orders of stay gets issued, because by close of business today, my Lord, we are going to lodge the notice, and that notice by itself acts as an appeal, and in the fullness of time, we shall be processing the application before the appellate court for appropriate orders to issue. My Lord, I therefore associate myself with my colleagues on the application for stay so that we don't have the proceedings before you in the fullness of time when we come to canvass the petition to be rendered nugatory or academic. My Lord, you have the discretion, and we ask and beseech you to exercise that discretion in the favor of the 9th petition. Thank you, my Lord.
My Lord, I would like to make an application under Article 1.1 directly. My lady. My lords and my lady, we are thankful for your ruling today and the lengthy explanations and court case that has gone into it. Unfortunately, my lords and my lady, it seems that some people are being favored over us, and in this matter, it is the states or advocates. We are here acting in person, and we are entitled to the same equal protection of the law. We are here trying to defend the Constitution and our constitutional rights. I am being discriminated against as a woman, as a person with disabilities, and as a youth, my lords and my lady. We filed our application on the 8th of October 2024. And we thought that we would be enjoined as interested parties to participate in Tuesday's proceedings, but we were not. So we did not have the time to ventilate our issues properly. My lords and my lady, we are asking you to stay your orders for 7 days, as you have told us to come back on the 7th of November, so at least we get a fair chance, a fair fighting chance as a sovereign to also ventilate our issues properly. The state cannot override us, and advocates cannot override us, my lords and my lady. This is a court for equality, and we are asking for equality. My lords and my lady, we also appreciate that regardless side has asked for 7 days to appeal. Kindly consider us in, because there is no point in justice. It will be granted to some petitioners, and others will just be thrown under the bus and into the darkness. Thank you.
My lord, if I may respond, my lord.
Sorry,
Your Honor, maybe I can also say one thing.
Can you just clarify your application? You say is dated the 8th of October?
8th of October, 2024.
The substance of the application?
It's petition E541 of 2024. We were seeking stay orders to stay the proceedings in the National Assembly based on Article 32(1), freedom of conscience, and Article 33, freedom of expression.
Your Honor, maybe with your kind permission.
Let me clarify. Is that the matter in which you are appearing with Dr. Eboso?
Yes, my lord.
Yes. Now, if you have been following the directions of this court keenly, we have been issuing various orders on consolidation. And I can assure you, I did that. And you and Dr. Bosso are petitioners in one of the cohorts. I think it's cohort number 1. Yes, it's cohort number 1. You are petitioners in cohort number 1. And we directed everybody to get into the CTS system. And whoever has a problem to get in touch with the deputy registrar. So it is not right, Ms. Wanjiru, to claim that you have not been enjoined in these proceedings. You have been enjoined, you are a party, and that is why we allowed Dr. Bosso to address the court, even yourself to address. So you are a party. You are a party. That one I can assure you.
My lords, we were not entitled to the right of enjoinder. And we had points that we wanted to defend against the respondent's side. So we're just finding it very difficult that due process is not being followed in our instance, as we applied even before both parties on the 8th of October 2024. They came to court on the 18th, 10 days after us, and they have still been granted audience before us, and we were told we're going to be in cohort 1, and then cohort 1, this application has already overtaken cohort 1. We're now being told to come next week after the swearing in would have been gone through and after numerous rights would have been violated that we have raised.
I think, Ms. Wanjiru, what you just need to do is just get into the CTS, get all the directions. There's every direction. There's a reason why we came up with cohort 1 application petitions and cohort 2 applications.
Yes, my lord.
So I think we may not wish to respond on whether you are discriminated or not, but we are so sure you are not discriminated because there are proper directions in respect of every cohort and every matter before us. Kindly take time to go through the CTS. Yes.
Thank you. This court had made directions on this issue. We said there are only 2 applications before this court right now, and those are 2 applications which will be responded to. We have applications. We are finished with this side.
You have not spoken on behalf of the second petitioner.
My lord, that we would like an opportunity to respond to both applications that are being brought today.
Maybe I can say one thing, just on behalf of the second petitioner. My name is Kimotho Teresia Wanjiru, Makazi.
Kerugoya.
Yes, there's Kimotho and Company Advocates Kerugoya. I just wish to say we welcome the ruling. However, there are some bits that we feel aggrieved and we wish to appeal. And therefore, as we do the notice of appeal, we are praying that we are in support of the issue for injunction, no the issue for stay, which the court may say it's a negative order, but we are saying pending the time we do the appeal, at least the status quo be maintained. And also we wish to say that there was an issue that the Court of Appeal today dismissed an application for stay. That is not true. We were told to serve. Parties were not all served, and that's the reason why we were given another date. So therefore, we are in support of these two applications that have been made today. Thank you.
Wanjiru, let's Wanjiru also. Mr. Dr. Iboso, yes. Please sit down. Please sit down.
My lord,
please sit down. Please sit down.
Will I be given a chance to speak?
Please sit down. Ms. Wanjiru, proceed.
Yes, my lord. As a young woman, I'm under 35, my lord. I'm actually 35. I'm a youth and I have a disability. And we're the only ones, I think, on the platform that check that we have a disability, my lords and my lady. Our Constitution, Article 1.1, has to count for something. Because it was intended for us to come to court directly.
Please respond to the application. Support, make the application.
Yes, my lord, I'm in support of the application. Most obliged.
My lord, finally. My lord, in response to the two applications.
My lord, there are three, not two. Up to four.
Oh, yours is also an application. Yes, my lord, in response to the application by my learned friend, Mr. Ochiel, future senior counsel, and my learned friend, Mr. Ndegwa Njiro, I wish to say it as follows, my lord. My lord, number one, the Madhu paper order sought by my learned friend fall on the basis of the following principles. Number one, my lord, there is already an appeal that has been filed in the Court of Appeal and an application for stay under Rule 5 to be filed, being application number 554 of 2024. The Court of Appeal is therefore seized of this matter, already seized of this matter. In those circumstances, my lord, a party can only apply for stay in the Court of Appeal. That's point number one. My lord, point number two, ordinarily, when a court delivers a ruling in a matter, the court becomes functus officio in respect of that particular matter. My lord, that matter therefore, or the applications made are therefore res judicata in the sense that a determination has been made, and this court cannot go back and approbate and reprobate at the same time. You cannot deny an order and then purport to issue the order again. Point number three, my lord. My lord, rules 23 and 24 of the Mutunga rules as presented before you, together with an application by my learned friend on substantive issues touching on actions that may be undertaken subsequent to this, including, my lord, the qualifications of the Deputy President nominee, Kindiki, can only be brought to this court, my lord, through one, either a new petition and a new application, or two, my lord, through an application for review. The only avenue that Mr. Ndegwa can bring all the issues that he has spoken to this afternoon are applications through review. No application for review or setting aside has been filed before this court by Mr. Ndegwa. And therefore it is inconceivable, my lord, that this court would entertain the application brought on several grounds, my lord, including grounds challenging the suitability or otherwise of the Deputy President nominee. My lord, lastly, and because my learned friend will submit further, once a court has delivered a ruling, my lord, the justice of the cause is that consequential processes can be undertaken given that there are no orders in place. And that is not for the court to be part of or to control. That is for other parties, probably not before this court, my lord. My lord, what you have done is dismissed the application of Conservatory. So that's a negative order. the court cannot be invited to review, to stay a negative order that has dismissed an application. And the negative order again goes to the application by Kimotho and Company Advocates from Kerugoya, who has also sought to stay your orders. Yet, all that application had, my lord, was for the former deputy president, former underlined, to apologize to NIS. Surely, Kimotho, you can do better. My lord, I'll invite my lion friend to go.
You are protected. You are protected.
No, Mrs. Kimotho and company.
Yes, my lord, my name is Muvomi Fienkolu for the second interested party. I have listened very keenly to the two applications, and the issues for you to weigh in your mind are as follows. One, if the outcome they seek through these two applications was declined by the Court of Appeal, not yesterday, but today morning, can this court, being a court lower than the Court of Appeal, on the very same day be seized of an